Under the Williams Act, a company seeking to acquire another company through a tender offer must provide the target company's shareholders with information regarding the offer so that shareholders can make knowledgeable decisions about whether to sell their shares. Additionally, many states have adopted their own statutes regulating tender offers. In the 1987 case CTS Corporation versus Dynamics Corporation of America, the United States Supreme Court considered whether a state's statute regulating tender offers was preempted by the Williams Act. In March of 1986, Indiana enacted a statute that required a majority vote of all disinterested shareholders in a corporation to give voting rights to an entity that acquires, quote, control shares, unquote, in the corporation. Control shares was defined as an amount of shares above 20, 33 1/3, or 50% of the outstanding shares in the corporation. In addition, shareholders had to vote on whether to grant voting rights to the acquiring corporation within 50 days of the proposed acquisition. Around the same time, Dynamics Corporation of America owned 9.6% of the stock of CTS Corporation. 6 days after the Indiana statute went into effect, Dynamics announced a tender offer for another 1 million shares of CTS, which would have brought Dynamics' ownership interest in CTS to above the 20% threshold under Indiana's statute. Subsequently, Dynamics sued CTS in federal district court, claiming in part that the Indiana statute was preempted by the Williams Act. Specifically, Dynamics argued that the 50-day allowance under the Indiana statute conflicted with the 20-day requirement of the Williams Act. Dynamics moved for declaratory relief, which the district court granted. CTS appealed to the Seventh Circuit, which affirmed. CTS then appealed to the United States Supreme Court.